So now you also have already the PowerPoint set. So you
Mhm.
may start now, please. The time is
Yeah.
yours.
Okay, well, thank you very much. Good evening again. Thanks for having me, and thank you very much for joining me in these very late hours of the evening, and to dedicate your time basically for the United Nations Convention on Contracts for the International Sale of Goods. Well, basically, I have a little bit less than 1 hour to talk about the convention, so maybe I will only put an emphasis to certain things that can be kind of different than what I know about your contract law regime and about your sales law regime, because this international convention was heavily built on the traditions of civil law legal systems, most notably German law. However, some of the common law elements are also infiltrated through the text, mainly because the United Nations has, the United States of America has been a party to the convention since its adoption in 1980. So, really briefly, just about some history and just to put you into context regarding the convention, as the title suggests, this convention is drafted under the United Nations, and it happened in 1980 in a conference that was held in Vienna, Austria. So forgive me if sometimes I refer to the convention as the Vienna Convention, or maybe I'm going to use the abbreviation, which is the most common form of talking about this convention, the CISG. Still, despite of the 1980 adoption of the CISG, we had to wait almost 8 years to enter into force, simply because according to the text of the convention, we needed at least 20 state parties to fully ratify the convention. So this is the reason we've been applying it since 1988, the 1st of January. And right now there are 97 countries that fully ratified the CISG. In fact, the number of signatories is 98 because Rwanda from Africa joined the convention in 2013, but up until today, they have not ratified it. So 97 state parties really don't even seem to be the vast majority of the countries registered at the United Nations. It's certainly kind of a little majority, but if you check the players, check the state parties, you can actually find some of the probably biggest economies in world trade, including the United States, almost all the European Union member states, also Russia, China, Canada, and even Mexico. Well, I try to do my best, and instead of listing all the 97 countries, I actually picked those that can be of interest to you that are either coming from Asia or from Southeast Asia in general. As you can see, there are not many. So basically, beyond South Korea, Vietnam, and Singapore, and most recently Laos, they joined only in 2023, so they are the newest members of the pack. Not many countries from Southeast Asia decided to sign the convention, not to mention any ratification. And unfortunately, certain countries are painfully missing from the list where international trade is quite dynamic. And the European Union or the United States have quite a lot of business with some of these countries. First, I have to mention the United Kingdom. The English were in Vienna in 1980, but they actually left on the third day of the conference. Basically, they had to accept that this is almost fully a civil law type of legal framework for sales contracts, and they just didn't want to join there. From the 27 European Union member states, only two countries decided to opt out, and that's Ireland and Malta. I don't think that this is going to come as a surprise because both of these member states are common law, and in fact, they are the only two common law jurisdictions in the European Union, so they are heavily influenced by English sales law. And from the rest of the world, you can see that unfortunately, even Indonesia never even considered joining the convention. However, the primary purpose of the United Nations by adopting the convention would be to provide for kind of a predictable set of legal framework for international businesses export and import businesses worldwide, so that they don't really just have to deal with choice of law clauses in their agreements. They can rely on a legal framework that's going to be the same in every single one of these 97 countries. And basically, the underlying rules for the most important transaction worldwide, the sales transaction, should be completely uniform. Well, unfortunately, we don't really have credible data on the efficiency of the convention, on how many contracts would actually rely on the CISG. I'm sure you read some statistics about everything else on the website of the International Chamber of Commerce. And sometimes they claim that the convention is still very popular, mostly for small and medium-sized enterprises in these 97 jurisdictions. But for the larger companies, especially for the multinational enterprises, the CISG doesn't seem to be a tempting legal framework. They claim that the reason for that probably is that the multinational companies have adequate resources, both financial and human infrastructural resources. So they are willing to pay money for the legal services when they are engaged in a big value international sales transaction. And therefore, they don't need any set legal framework, not just the CISG, but even beyond that, any of the national laws. They would like to create kind of a mini code of obligations or sales law for their contract. Anyway, as you know, most of these contracts are confidential, and the businesses typically don't disclose anything about that. So we don't know much about the efficiency of the CISG. We can only rely on the published judgments of the national courts in the 97 jurisdictions. Every year, we can see that there are a few hundreds of these decisions relying on the convention in the European Union, in the United States, and sometimes in other jurisdictions that decided to join the CISG. Well, before we get into some of the operative rules of the convention, first, I think it's always important to clarify the scope, the geographical and the personal scope of the convention. Well, the convention says that the sale must be international, and there's a definition for this international element, meaning that the two parties of the agreement, the buyer and the seller, must have their places of business in two different countries. Well, while it sounds pretty obvious, I have to tell you that there's no objective definition for place of business set in the convention. And since the convention has a preemptive nature, meaning that it's completely absorbing all the national laws when we apply that, so you can't use, let's say, Hungarian law to fill in the gaps, or you can't use Hungarian law to rely on certain terminologies or interpretation that's not clearly settled by the convention, because the convention requires kind of a standalone application. So we will get back to this place of business and the definition of that, or the lack of a clear definition for that, through a case, just to show you that this blurriness in the convention often gives ground to some judicial discretion, and obviously judges somehow have to come up with a workaround, and they have to set what place of business they clarify and they basically consider as the determining factor when establishing the scope of the CISG. So the two parties are coming from two different countries, whatever place of business actually means, and either both of these countries are contracting states, meaning that they fully ratified the CISG, which is kind of an obvious thing. If a Hungarian seller sells something to a Romanian one, then even if they basically decide that they will apply Hungarian law, this is going to be the CISG, because both Romania and Hungary are signatories to the convention. So that sounds like an easy thing. However, the second rule, which is an alternative to establish the scope, is a very tricky one. People often say that this is kind of a backdoor on how to sneak into the jurisdiction of non-contracting countries, because it can easily happen that an Indonesian business, even if Indonesia never joined the CISG, will be subject to the application of the convention through this second rule. The rules of private international law lead to the application of the law of a member state of the convention. What does it mean? If an Indonesian business sells something to a Hungarian business and they decide to apply Hungarian law, then since private international law typically respects the choice of law clauses of the participants of the contract, and Hungary decided to replace its own legal system specifically for international sales contracts with the CISG, then if there's going to be any legal dispute arising from this contract, and the parties turn to a Hungarian court that must apply Hungarian law based on the choice of law clause of the seller and the buyer, then it's going to be the CISG. Even if one of the businesses in my example is an Indonesian non-contracting country business. Well, since the drafters of the CISG felt that this is a very sensitive issue, they allow for a derogation to any of the countries that joined the convention. So upon ratifying the convention, the contracting party, the country, can actually declare that they are not applying this backdoor provision, and they only enforce the CISG against businesses coming from jurisdictions that joined the convention. So as an exception, the United States lived with this derogation. So US federal courts are not willing to enforce the CISG against third country businesses, only if the business is also coming from a contracting state. So this is kind of the important geographical determination of the scope of the convention. Well, here comes the second, probably bit surprising fact about the convention. Most of these treaties or conventions in the international business law domain are typically only applicable if the parties specifically point to the application of that international regulatory instrument. Well, the CISG is different. The CISG acts as if it was kind of a civil code. That's always there, that's always in the background, and therefore the CISG doesn't require the explicit incorporation of the seller and the buyer into their sales contract. They just, have to point to the application of a legal system that's a CISG country. So even if the businesses don't say a word about the convention, but they say that for the sales contract, Hungarian law applies, then this is going to be the CISG. And I have to tell you that sometimes this unconditional application of the CISG can lead to misunderstandings. I'm just following a case here in Hungary in front of the Metropolitan Court of Budapest, where there's a legal dispute between a Hungarian buyer and a seller from Belgium. Both of these countries are CISG countries. They made a simple sales contract. The Hungarian business purchased some tents from the Belgian manufacturer, and they decided to apply Hungarian law. But there were some quality problems with the products, and the Hungarian buyer sued the Belgian seller in a Hungarian court. And the court immediately concluded that this is not the Hungarian civil code that applies, it is the CISG. And I have to tell you that the lawyers representing the two parties, the seller and the buyer, were genuinely surprised because they had absolutely no clue what the CISG was, and probably the contracting parties, the seller and the buyer, had no intention of applying anything else other than the Hungarian civil code. But they cannot do anything against that, because upon agreeing to the terms of the contract, you can certainly opt out. And the parties with mutual consent can decide that they do apply Hungarian law, and they exclude the CISG from this coverage. They can do that. But if they only say it's Hungarian law, or it's the laws of Texas, or it's the laws of Germany, then this is going to be the CISG. So please keep it in mind that this is exactly when you're applying your civil code and your contract law that most of the rules are free from derogation. So the parties can override them, the parties can decide to set them aside. But if they don't do that, it's in the background and it's going to be in the background all the time. So this is exactly how the CISG operates. So there's a fairly famous case from the United States from 2001 that's going to show you how determining the scope of application for the CISG can be quite tricky and problematic. It's the Asante Technologies versus PMC Sierra case. Asante was a corporation incorporated in one of the member states of the United States, Delaware, with its headquarters in California. But Asante ordered component parts for the switchers it manufactures from PMC Sierra, another business that was originally registered in the United States in Delaware, but having its headquarters in British Columbia, Vancouver, that's another country, Canada. 4 of the 5 orders under this contract were placed through a company called Unique Technologies. It's one of PMC Sierra's authorized distributors, also in California. And only the 5th order was sent directly by fax to PMC Sierra in Canada. Asante sued PMC in a California state court, considering that this is basically a domestic legal dispute. Well, I was dealing with a company that went through, for the majority of the performance, another Californian company, Unique Technologies. So most of the products under this contract never even had to reach and never even had to cross any borders. They were coming from the warehouse of Unique Technologies, a Californian business. Now, because Asante is a Californian company headquartered in California, getting most of the products from a Californian warehouse, he believes that this is a fully domestic Californian matter, so he sues PMC in a California state court. Well, PMC contests this argument and it manages to remove the lawsuit to a US federal court, claiming that this is an international dispute, and therefore a California state court has no jurisdiction to hear the case. Now, if you have to decide where are the places of business for Asante and for PMC Sierra, you can see that there are quite a big blur in here. You can get to a conclusion that both of the companies, Asante and PMC, are registered in the United States, right? In Delaware, the same state of the United States. So you can say that this is not a CISG transaction simply because there's no international element in here. But the other scenario is that you only deal with the headquarters of the companies. And in this case, PMC is headquartered in Canada, Asante is headquartered in California. So this is a CISG transaction because it's an international sales contract. And the third question is whether you have to pay attention to Unique Technologies, who's just a distributor, who was not party to the contract in the position of being a seller or a buyer. It was basically nobody else than simply a distributor that PMC Sierra instructed to serve Asante from the warehouse. Well, the American court got to the conclusion that place of business, in lack of a clear definition in the CISG, should always be the places where the actual party, the company operates, that has the closest connection to the transaction. Delaware has absolutely no connection to this sales contract. Delaware is just a place for an act that both companies were incorporated there. But this is irrelevant from the perspective of the sales transaction. Unique Technologies is not a seller and it's not a buyer, so it's not a party to the contract. And since the CISG claims that we have to determine place of business only for the parties and not for the so-called third parties that's going to help the seller to perform its contractual obligations, that we should also rule unique technologies out of the equation. We don't care about that. So we are left with Asante and PMC Sierra, and the actual place of business where they are physically operating is for Asante, it's California. For PMC, that's Canada. So the US federal court concluded that this is a CISG transaction because if the parties said that it's the laws of California that's going to govern the contract, this is the CISG, as the federal government of the United States decided to replace all state sales laws with the CISG if it's going to be an international sales contract. So basically, the lesson learned from this case is that place of business should be the actual place of operation for the buyer and the seller that has the closest connection to the contract. So after determining the so-called geographical scope, let's jump to the subject matter of the convention. It's another surprising fact that sale and sales contract is not defined by the convention. I have to tell you that there's a reasonable explanation for that, since the definition of sales can be quite different in the various jurisdictions. Some jurisdictions put an emphasis on the transfer of title, of ownership over the product. Other jurisdictions don't really care about the transfer of title. They do care about the physical handing over of the product. So this is the reason the CISG decided to leave a definition for sales contracts out of the story. And instead, we use kind of an implied definition that's almost purely factual. We don't care about title of ownership. We care about the physical, most important obligations of the parties. So it's the delivery of the goods and their supporting documentation by the seller and the payment of the price by the buyer. As you can see, no lawyering in here. If you can identify any of these elements to be the governing elements of the transaction, you can say that it's a sales contract. And if the other conditions of internationality are met, then it's under the scope of the CISG. Also, products, goods.
Professor,
Yeah,
maybe you can stop for a while because there
okay.
is one student, some students, they request me to do some summarize in Bahasa.
Oh,
So
okay.
just let me translate and then
All
so
right.
they may understand about your explanation. Jadi hari ini kita akan membahas konvensi yang dibuat oleh PBB tentang perdagangan barang secara internasional. Konvensi ini sudah diratifikasi kurang lebih 97 negara, namun sayang sekali salah satunya Indonesia belum meratifikasi sampai saat ini. Bahkan negara-negara lain seperti misalnya Rwanda dan lain sebagainya mereka sudah meratifikasi, termasuk Amerika Serikat. Dan konvensi ini bisa berlaku dalam hal apabila kedua negara itu melakukan ratifikasi, baik ke negara penjual dan negara pembeli. Dan kemudian dalam hal yang lain, konvensi ini bisa berlaku apabila misalnya secara geografis para pihak yang para pihak yang melakukan perjanjian jual beli barang internasional ini dia berasal dari negara yang meratifikasi konvensi atau dengan menggunakan klausula pilihan hukum. Jadi apabila ada para pihak mereka bukan berasal dari negara yang meratifikasi konvensi, tapi mereka dalam perjanjiannya itu memilih klausula pilihan hukum, hukum di mana negara yang sudah meratifikasi maka si ISG bisa berlaku. Dan juga yang kedua, hal yang harus diperhatikan itu adalah konvensi ini berlaku khususnya untuk berkaitan dengan penjualan barang saja. Jadi barang tapi tanpa perlu melihat histori dari barang itu sendiri. Misalnya cukup hanya barang beserta dokumennya diserahkan dan pembayaran dilakukan oleh pembeli. Itu sudah terjadi kontrak perdagangan barang secara internasional. Yes, you may continue, Prof.
Well, thank you very much for the summary. So one more thing about the scope, goods. What type of goods can be subject to a sales contract which is under the scope of the convention? It's also not directly defined. In fact, the convention only provides for a negative list. What type of goods are not considered to be regulated by the convention? However, one thing is absolutely clear since the CISG only applies to business transactions. So both the buyer and the seller have to be businesses and not private individuals. And we are talking about real cross-border transactions, real estates, unmovable property is out of the equation. So it's only about tangible, movable goods. The CISG says that consumer contracts, if the goods are purchased for personal, family, or household use, these are not regulated by the CISG. Remember that the main reason why the United Nations adopted the text is not to kind of provide for consumer protection. It's more about giving businesses, professional companies, a reassurance that they can rely on one unified piece of legislation. Also, if the sales contract is made in the form of an auction, when bidding is involved, that's not a CISG transaction. And if the contract was made in the framework of an execution or performed by the authority of the law, think about bankruptcy or insolvency, then it's also not a CISG transaction. And some limited number of products are specifically excluded from the coverage of the CISG when we are talking about negotiable instruments like securities, right, or money, ships, vessels, hovercrafts, and aircrafts, and also electricity. They are not considered to be CISG transactions. So domestic law is going to govern these contracts. So what is the reason for this list of exclusions? It's very simple. For some of them, by the time the convention was adopted, a fairly detailed international legal framework was made. And the CISG didn't want to be in collision with that already existing rules. That's the reason for leaving electricity out of the equation. We have quite a few of these regional conventions, especially in the European Union, for trading over electricity. When it comes to these vehicles, ships, vessels, hovercrafts, or aircrafts, I'm sure if you went through a private international law course, you remember that historically, starting from the Middle Ages, the law that governs on board these vehicles and also over the transaction involving these vehicles is the law of the flag, the law of the place of registration, and therefore the CISG didn't want to mess with that either. And when it comes to the securities and negotiable instruments, also if you remember the 1931-1932 Geneva Conventions on bill of exchange, promissory note, and checks, that's a detailed legal framework that also tells a lot about transfer of ownership over these securities. So the CISG did not want to collude with the already existing legal framework. However, two questions are left somewhat open. So it's understandable that when it comes to the determination of the sales contract, we only deal with the physical, tangible obligation, the main obligation of the parties. Remember, delivering the product, paying the price. But what can we do with transactions that we call mixed sales transactions? When the sales element is just one of the multiple elements in the contract, like there's also traces of service contracts involved. Like my university just ordered a very sophisticated medical technology from China, from the Chinese intellectual property rights holder in Shanghai. And the value of the transaction was 3.6 million US dollars. This technology must be manufactured by the Chinese IP holder and also the manufacturer. They had to ship it into the European Union in a disassembled form. They had to assemble that here in Debrecen, in my hometown. The Chinese had to obtain the permissions from the European public health authorities so that the machine will be able and will be capable of curing patients in the EU. And they also had to train the employees of the university on how to use the machine. So if you see, it's much more than just a sales element. There's a lot of services that the Chinese were willing to do. So is it a CISG contract or not? Well, the CISG says something really blurry. Mixed sales and services contracts should be treated as sale of goods unless the preponderant part of the obligations of the seller consists in the supply of labor or other services. What does it mean? Preponderant is not a legal terminology. We don't even know what it means. It means that it's probably an important determining element of the transaction that's not the sales element. But how should we determine that? Do we care about the value? So from the 3.6 million US dollars in my example, should we calculate the actual market value of the machine itself? And if it's more than half, then it's a CISG contract. If it's less than half, it's not a sales contract in the sense of the CISG. We don't know anything about that, and the sad reality is that the courts in the 97 jurisdictions basically use very different concepts, very different approaches on how they determine and how they interpret preponderant. Is it about the cost value, the price value? Is it more about what's the most important obligation from the position of the buyer? This remains a bit unclear. And also another question that's partially not settled by the convention. Many of these contracts are about future sales. So we agree that I'm buying something from you, but that product is not in existence yet. After making the contract, you start manufacturing them, and when you're ready, you're going to ship it to me. So what can we do with these future sales? According to the CISG, they are sales contracts unless the buyer undertakes to supply a substantial part of the materials. So again, substantial is not a legal term. What does it mean? If the buyer provides for some of the materials for the manufacturing, then this is hired labor and not sales in the sense of the CISG. But how do you determine substantial part? Again, typically courts in the 97 jurisdictions care about the price, and they try to find out that regarding the accessories that the manufacturer seller needed to make the goods ready, most of them should actually come from his own source and not given by the buyer. If this is the case, then it's a sales contract, even in light of the CISG. I'm going to stop for a minute. If Professor, you would like to make a summary in Bahasa, then
Okay,
probably it's a good time for that.
thank you. Jadi tadi ada beberapa persyaratan mana saja yang bisa dilakukan perdagangan barang secara internasional. Tadi disebutkan syarat yang pertama secara geografis harus dilaksanakan di negara yang bisa meratifikasi dengan ketentuan-ketentuan khusus tadi. Ada pengecualiannya juga. Kemudian yang kedua tadi terkait dengan harus barang gitu ya, yang dikirim begitu ya, beserta dokumen, tapi tidak perlu ada pembuktian pengiriman atau pemindahan status hak milik. Jadi mereka tidak memperdulikan itu. Kemudian yang ketiga, yang tiga ini adalah area barang-barang apa saja yang bisa diperdagangkan. Jadi seperti barang-barang yang digunakan untuk kepentingan bisnis gitu ya, untuk bisnis transaksi bisnis. Jadi harus dilakukan antara perusahaan badan hukum dengan badan hukum, bukan individual. Kemudian bukan juga barang yang sifatnya permanen, tetap, benda tetap gitu ya, seperti tanah, bangunan, tetapi hanya barang-barang, benda-benda yang sifatnya bisa dipindah gitu ya, movable. Kemudian bukan juga untuk kepentingan personal, juga bukan barang lelang, kemudian bukan juga saham, bukan juga kapal, karena memang akan terjadi benturan dengan beberapa konvensi Jenewa, bukan juga barang-barang elektronik. Dan syarat yang keempat itu adalah sales, penjualan barang, tapi ada apa hal-hal lain yang melekat, seperti misalnya tadi dicontohkan apabila kita membeli alat-alat kesehatan, misalnya untuk UII, untuk rumah sakit, dan alat kesehatan ini harus dikirim dari Cina, begitu. Barang ini bisa berlaku konvensi CISG itu tadi, tetapi kemudian ada pertanyaan karena kan alat kesehatan ini mahal sekali dan biasanya nanti akan dibekali dengan pelatihan-pelatihan atau mungkin dari Cina akan mengirimkan semacam pengawas atau mereka yang akan melihat secara langsung bagaimana alat kesehatan itu bisa dilakukan dengan baik begitu ya, memberikan pelatihan kepada tenaga kesehatan kita gitu ya, sehingga dan mereka juga melakukan semacam pengecekan barang gitu ya untuk maintenance-nya gitu ya. Terus kemudian apakah kemudian ini bisa berlaku? Sebenarnya bisa asal ini berkaitan dengan barang itu sendiri. You may continue, Prof.
Thank you very much. So let's jump into the first big chapter, the first big operative chapter of the convention, which is about the formation of the contract. It's very standard, and actually, it looks like something you copied from your own civil code. Obviously, we do care about the meeting of the minds. We need an offer that's accepted by the other party, and we have this perfect overlap of the two proposals. This is when we have a contract. The CISG doesn't require any form. It doesn't establish any formal requirements for the contract, so it doesn't have to be in writing. Even oral agreements or agreements that you can evidence through various conversations like exchange of emails, phone calls, that's also going to be suitable for that. So this is not surprising that if the contract doesn't have to be made in a specific format, also the offer and the acceptance do not have to follow anything special in this regard. There is, however, one really specific approach in the CISG, which is not standard even in civil law legal systems. I have to tell you that I don't know your contract law in these details, so I'm not sure whether this is the case in Indonesia. It's certainly not in Germany. It's certainly not in France. So this is a kind of an interesting CISG concept. So typically the offer must be fully accepted, and any modification that's going to be made compared to the offer is going to be a counter offer. So the whole contracting process will start over. If I'm going to tell you that I'm selling this bike for $100 and you tell me that you're buying it but only for $80, then you made a new offer and the ball is on my side again, that I have to accept it, or I also make modifications. And we play this game all the way until we have a complete understanding and kind of an agreement on all the elements of the contract. However, there are certain exceptions in the CISG. The CISG says that a so-called would-be acceptance that contains material differences from the offer is a counteroffer. So if the modification from the offeree is going to be non-material, then it's not going to be a counteroffer. It's going to be considered as an acceptance. So let me tell you how it works. The CISG lists the so-called most important elements of the sales contract, and if there's any amendment coming from the offeree regarding the offer that's going to be about these material differences, then there's no agreement. It's a new offer. Price, payment, quality of the goods, place or time of delivery, and the extent of one party's liability to the other, and finally the manner of settling disputes. So if the communication, the proposal of the offeree will touch any of these 6 material differences, suggesting an amendment, then there's no deal, it's a counteroffer. But anything beyond that will not be significant. So let me tell you an example. I'm making an offer that I'm selling you 500 cars for a certain amount of money. This is the delivery deadline. That's the payment I expect, the method of payment. And you come back to me and you say, fine, but you want me to send you a notification 5 days prior to shipping these cars to your destination. So in many, many civil law, contract law systems, even if it doesn't seem to be something like a material difference compared to my offer, it's not gonna constitute an agreement. But in light of the CISG, it's very different. Since a notification duty is not listed as one of the material differences, right? Then basically we made a deal. And if I don't promptly object that no, I can't notify you 5 days in advance, so I don't promptly object, we have a deal, we made a contract, and this contract will be formed especially with the content of my offer plus your additional suggestion on the notification requirement. So I hope it's clear and you understand that anything which is an amendment to the offer beyond the 6 material differences, that's not going to be considered a counteroffer. It's in fact an acceptance. Okay? So, sir, I'm gonna give you time to give a summary on that before we jump to
Okay.
breach and
Yeah.
remedies.
Okay, so basically jadi apa syarat saat ini kita masuk pada bagaimana cara melakukan kesepakatan khususnya ketika kita berencana untuk membeli barang-barang secara internasional begitu ya. Kemudian yang pertama harus ada meeting of minds itu harus ada kesepakatan. Nah, kesepakatan itu ditandai dari adanya penawaran dan penerimaan. Nah, memang dalam faktanya memang kadangkala bisa apa berbeda-beda begitu ya. Misalnya kalau di negara-negara civil law countries biasanya mungkin ketika kita apa menerima begitu ya, kadangkala kita juga meminta ada syarat-syarat di luar dari kesepakatan awal, misalnya kita meminta adanya notifikasi dan lain sebagainya. Nah, apabila penjual ini ternyata tidak memberikan respon begitu ya, mungkin bisa jadi di situ ditandai bahwa telah ada kesepakatan. Jadi kesepakatan itu sangat penting sekali dan syarat untuk menyepakati dalam hal pembelian barang secara internasional itu harus ada penawaran dan penerimaan. Jadi kalau misalnya tadi dicontohkan ada kurang lebih pembelian mobil 500 unit dikirimkan ke kita begitu ya. Dan kita siap membayar dan kita sudah sepakat, tapi kemudian kita menawarkan kembali harus ada notifikasi 5 hari sebelum lunas begitu. Maka jika penjual itu tidak merespon, mungkin itu juga bagian dari kesepakatan. Yes, you may continue.
Okay, thank you. So I didn't mention to you that the CISG, despite of this preemptive nature of the convention, doesn't provide for a complete description of sales contracts. It only focuses on 2 elements, formation, as you saw that, and breach and the remedies available for the breach of contract. And nothing else, like the legality of the contract, invalidity, and representation, these are completely missing from the convention. Obviously, when it comes to a legal dispute that's not touched by the convention, so let's say that one party would like to declare the contract invalid, then since this whole question of invalidity is missing from the convention, this is going to be national law. So let's jump to the next one, the last chapter basically of the convention, which is the biggest. It's about breach and remedies. Also, because time flies and I only have probably like 10-15 minutes left, I would like to only highlight 2 interesting scenarios and approaches from the convention. First of all, breach in most legal systems, even in common law, if we talk about English contract law, doesn't really make a difference between the various degrees of breach. If one of the parties does not fully comply with the promise, with the agreement, that's going to be a breach. Even the slightest derogation in performance will be a breach, right? Probably this is the case in Indonesia too. However,
Yeah.
I'm not fully uh, aware of that. Anyway, the CISG works differently. It actually makes a difference between two types of breach scenarios. There is a so-called fundamental breach, which is the more stringent, the more serious breach scenario when one party to the contract substantially fails to deliver what the other reasonably anticipated receiving. Again, a pretty blurry definition. What does it mean? It actually means that the CISG doesn't list specific duties, specific obligations for the buyer and for the seller. And if one of them breaches this particular duty, then this is going to be a fundamental breach. It's quite the opposite. We take the position of the innocent party, the non-breaching party, and we see what's the consequence of the breach onto him. And it's very obvious that if the seller fails to deliver products, then this is going to be a fundamental breach from the buyer's perspective, because the buyer's most important motivation is to get the product right on time. If the seller fails to do that, that's a fundamental breach. But maybe if the buyer receives non-confirming products, so the delivered goods are not fully compatible with the description in the contract, even if you think that this is probably a fundamental breach, it's not necessarily one. Because I can tell you about a fairly famous case from Germany, the so-called shoe seller case, when a German buyer operating shoe stores for customers across the country ordered certain shoes from an Austrian manufacturer. When the shoes were delivered, not the entire shipment was in conformity with the sales contract, as some of the shoes were not the size that the German buyer ordered from the Austrian seller. So it's a non-conformity problem. However, the German court concluded that this is not a fundamental breach, because we are talking about a buyer that sells shoes for consumers across Germany through its retail shops. And in this regard, he can probably sell shoes that are not size 48. People also need size 41, size 43, right? So in this regard, there's no question it's a breach. But when it comes to the remedies, the buyer cannot apply those remedies that are only available for the instance of fundamental breach, because this breach, delivering not perfectly confirming shoes, will not fall into the category that the seller substantially failed to deliver what the buyer anticipated in receiving. So this differentiation is crucial in the CISG. Whenever there's a breach and the innocent party would like to rely on one of the remedies available in the convention, the first question you have to decide is whether the breach is fundamental or not. And I'm going to tell you why. If the breach is fundamental, then the most classic remedy provided by the CISG is avoidance. Avoidance is not cancellation, even if it has some resemblance to that legal institution. Avoidance is very simple. If the innocent party decides to avoid the contract as a response to the breach of the other party, then it means that I'm going to be completely excuse myself from performing any obligation required by the contract. And I also send a message to the breaching party that I don't want his performance anymore. So just to give you an example, if there's late performance, the seller was supposed to deliver the goods on a specific date and he's late. He can't do that. Delivery arrives a week later. The buyer can claim that, I'm sorry, my contractual interest is completely gone. I don't need these products anymore because I needed them a week ago. I think it's a fundamental breach from my perspective, because a week ago these products did not arrive. So in the last minute, I had to purchase it from another source because I needed it in my manufacturing process then and not a week later. So now I'm avoiding the contract, meaning that I won't accept the seller's delivery. I won't take delivery at all, simply because I avoided the contract. But it's not cancellation, because if you cancel the contract, then the entire contract is gone. It's going to be terminated. Here, other than the obligation to perform, the rest of the contract will survive avoidance and it will remain in place. So back to the original question, why is it important to differentiate between fundamental breach and non-fundamental breach? Because the innocent party can only avoid the contract if the breach was fundamental. If the breach was not fundamental, avoidance is not an instant option. First, the buyer has to send a notification. The innocent party has to send a notification to the breaching party that I give you an additional period of time, a grace period, to comply with your obligations. And if you do so, that's fine. I'm going to accept it as a legit performance. If not, and that period runs out unsuccessfully, then I'm going to avoid the contract. So remember, fundamental breach, instant avoidance. Non-fundamental breach, avoidance only comes after an additional period of time given to the breaching party to comply with the performance obligations. Okay, sir. So you may translate it if you want.
Thank you. Jadi ini ada penjelasan yang sangat menarik, khususnya berkaitan dengan one prestasi. Jadi dianggap salah satu pihak itu, menurut si ISG, dia melakukan one prestasi secara mendasar gitu ya, apabila salah satu pihak itu tidak mengirimkan, khususnya penjualnya gitu ya, barangnya. Jadi yang dianggap fundamental breach atau one prestasi secara mendasar itu jika para pihak atau pihak penjual itu tidak mengirimkan barangnya. Jadi jika salah satu pihak tidak mengirimkan produknya, dari perspektif pembeli itu merupakan bagian dari fundamental breach. Dan juga di dalam CISG juga diatur berkaitan dengan avoidance. Jadi penghindaran. Maksudnya penghindaran itu adalah ketika kemudian telah terjadi one prestasi yang secara mendasar dilakukan oleh penjual, maka pembeli bisa mengatakan bahwa dia tidak akan melaksanakan eh, kewajiban-kewajiban atau prestasi-prestasi sesuai yang disepakati karena telah terjadi one prestasi yang mendasar itu tadi. Thank you, Prof. You may continue.
Thank you. So let's jump to the last thing I would like to highlight for you in this time frame. One of the most important and probably most used remedies provided by the CISG. This is damages. So the concept of damages in the CISG is also something that was unique in 1980. Right now, and I can only talk about the European Union, it doesn't seem to be such a big novelty anymore because many of the EU member states in the past 20-25 years, they amended their contractual liability regime, and most of them now follow the CISG's approach. Liability for damages in the convention is a strict no-fault liability approach, meaning that we don't care about the intention, we don't care about the negligence of the breaching party. The concept of the CISG is different. It actually believes that the contracting parties are both professional businesses. Nobody forces them to make a contract to buy or sell anything. And therefore, if they are willing to enter into a sales contract by mutual agreement, then they have to keep their end of the bargain. And they shouldn't be excused from performance, referring to certain circumstances that may be in their control or that may be foreseeable or that they are part of the ordinary business risk. So just to give you a few ideas, if the Hungarian business sells something to a German business and the price in the contract is determined in euros, not in the Hungarian currency, forints, and in the time of payment, the currency exchange ratio between the Hungarian national currency and the euro will substantially change, then it's irrelevant. This is not going to be an excuse for the party, the breaching party, to escape from the obligation to pay, simply because the exchange ratio fluctuation, it's a common business risk. The manufacturer seller cannot say that, my employees got sick, because it's kind of an ordinary business risk. You can't say that the machinery that I use for manufacturing broke down and it needed time to find the replacement, and that's why I was late in performance. It's irrelevant. We don't care how diligent the breaching party was in order to avoid damages. He is going to remain liable for recovering the loss of the innocent party. So this is what no-fault liability means in the CISG. Well, this is a really stringent rule, and it imposes a serious liability on the parties. In exchange for that, the CISG does not foresee a so-called full compensation. So if you think about lost profit, for example, this is not necessarily something that the innocent party will be compensated for, because the CISG claims only the foreseeable damages will be paid by the breaching party, damages that the breaching party knew or should have foreseen at the time of making the contract. Why is it important? Because in the light of the CISG, we expect businesses to make kind of a full disclosure to each other when they are making the contract. So if the deadline for performance is particularly important for me for some reason, then I have to be specific about that. Let me tell you an example. It's also a German case. I'm sure you all know the German manufacturer, automobile manufacturer, BMW. BMW had a contract with a Japanese buyer, the Japanese importer. They had to manufacture and ship 500 BMW cars to Japan for a certain deadline. BMW did not manufacture all the components for the cars, and the car tires were manufactured by another enterprise, Continental. So BMW made a contract with Continental that I need car tires 2000, right? If I'm counting correctly, for the 500 cars, they all have 4 wheels, okay? So I need 2000 car tires by this deadline because BMW calculated that in the manufacturing timeline, that's gonna be the point where they need the tires and they will equip the almost finished vehicles with the tires. And that was obviously very close to the performance deadline toward the Japanese buyer. Continental breached the contract, and with some manufacturing difficulties, they were unable to deliver the car tires on time. And this was the reason BMW was late in performing the Japanese contract, and they shipped the cars into Japan with a 1-week delay. However, in the Japanese contract, the Japanese buyer insisted on a really hefty penalty. For every day of the delay, the Japanese buyer insisted on 1 million euros as a penalty for late performance. When BMW sued Continental, claiming that because of your breach, now I lost money, and it's not just that I was not able to manufacture the cars on time, I also had to pay a big amount of penalty toward my Japanese buyer. Continental was shocked, and they said, this is an outrageous amount of money. Basically, ultimately, you had to pay more in penalty to the Japanese than the aggregated value of all the cars, right, that you delivered. So this is an information that you should have shared with me upon making a contract for the car tires, because if I, Continental, had known about this fact, that I'm taking such a big risk, I probably would have charged you more. You understand the logics, right? That
Yeah.
if I know that I'm facing an extraordinary risk, something which is not usually foreseeable, every car tire manufacturer probably foresees that if they breach the contract, they don't supply the car manufacturer with the tires on time, then the car manufacturer will pay some penalty. But if the amount of the penalty is that outrageous, it's kind of expected under the CISG from BMW to inform Continental about that upon the initial formation of the contract. So Continental was found liable for the breach by the German court, and they had to pay damages, excluding the amount of the penalty paid toward the Japanese buyer, because it was not foreseeable for the breaching party, for Continental. This is what foreseeability means in this regard. And the final word, the exclusion, how can you defend yourself against a claim for damages under the CISG? Force majeure is strictly defined in the convention. A party is not liable for damages if he can show that the failure was due to an impediment beyond his control. The impediment was not something he could have reasonably taken into account at the time of making the contract, and he remains unable to overcome the impediment or its consequences. Now it's a really, really complex regime for defense. All three conditions must be met in order to escape liability from damages. Let me tell you a story. Unfortunately, it's not a real one so far because it's an ongoing litigation also in Germany. German manufacturer sold something to France. In 2020, the end of March was supposed to be the deadline for delivery, but the Germans were unable to meet this deadline for delivery because of the coronavirus pandemic. In the middle of March 2020, the German government imposed restrictive measures on the operation of businesses. I'm sure you are all aware of that, right? Because you all remember that scenario. So people couldn't go to work and stuff like that. And that was the reason the German company was unable to manufacture the products on time and to perform the contract. Is it a force majeure or not? Probably it is. We don't have a decision yet, but this governmental restriction is certainly beyond the control of the German manufacturer, the seller. I mean, up until 2020, nobody believed reasonably that a government in Europe can apply such restrictive measures that will practically seize businesses from their money-making potential, right? The last time it happened was in the Second World War. That was 80 years ago, right? So that's beyond control. It was unforeseeable because late 2019, when the contract was made, the coronavirus situation seemed to be like a remote Chinese isolated problem. No European businesses reasonably thought that this is going to come to Europe, right? Third, since there was no way to manufacture the products for the German seller, there was no reasonable measure taken to overcome the impediment. So back then in 2020 March, this was probably a force majeure. But in 2022 January, is it still a force majeure when there was the fourth wave of the coronavirus pandemic? And that was exactly the fourth time the German government applied the same restrictive measures in containment of the virus. So back then, if you made a contract in 2021, when we all lived in the pandemic world, and we were aware that this is a business risk now. It's not an extraordinary situation. It comes back periodically, and governments would react to that almost exactly the same way as they did in the past 1, 2, or 3 occasions. Then this is, even if it's beyond the control, but this was not unforeseeable, and therefore, if this is the reason, this is the impediment that the party breached the sales contract, then it's not a force majeure, and he remains liable for damages. Okay, sir, but that's the last part that you may translate.
Oke, terima kasih. Thank you. So, jadi tadi disebutkan bahwa berkaitan dengan kerugian, jadi apabila ada para pihak yang melanggar perjanjian, maka kemungkinan pihak yang lain, lain akan menderita kerugian dan pihak yang menderita kerugian akan meminta ganti rugi. Nah, berkaitan dengan ganti rugi ini harus dapat diukur dengan baik begitu ya, atau foreseeable itu ya, harus bisa diprediksi dengan baik. Jadi apa misalnya tadi dicontohkan kita dari Indonesia akan membeli 500 ada perusahaan di Indonesia akan membeli eh, mobil BMW dari Eropa 500 unit kemudian perlu diketahui dan deadline-nya mungkin bulan depan Januari tanggal 15 misalnya. Dan perlu diingat, sudah disepakati demikian, tapi perlu diingat bahwa perusahaan BMW itu kan tidak semua komponen mobilnya itu kan berasal dari Jerman. Mungkin rodanya bisa dari Thailand, mungkin bagian chassisnya bisa dari Jepang, dan mungkin bisa jadi bagian-bagian lain berasal dari negara-negara lain. Sehingga kemudian apabila ternyata mereka terlambat mengirimkan jadi seminggu gitu ya, jadi tanggal 25, maka bisa jadi pihak perusahaan Indonesia tadi merugi dan bisa mengganti rugi. Dan di beberapa negara, seperti misalnya di Jepang, kalau ada pihak yang melanggar perjanjian, itu biasanya kena denda dan dendanya sangat tinggi sekali. Nah, sehingga kemudian itu akan sangat merugikan pihak yang lain. Nah, yang seperti ini harusnya eh, diberitahu dari awal kalau memang semua komponen-komponen itu tidak semuanya dari Jerman. Dan kemudian pihak-pihak mitra-mitra dari perusahaan BMW juga harus diberitahu bahwa apa barang-barang tersebut apa harus diselesaikan sampai tanggal berapa seperti itu. Nah, hal yang seperti ini kadangkala masuk dalam kategori unforeseeable dan itu bisa bebas dari gugatan ganti rugi. Dan juga ada force majeure. Force majeure itu sebagai salah satu alasan bagi para pihak ketika misalnya ada wan prestasi tetapi ternyata wan prestasi itu dikarenakan adanya keadaan-keadaan di luar kendali manusia, maka itu diperkenankan selama itu memang benar-benar itu adalah karena terjadinya force majeure seperti misalnya banjir, kemudian bencana alam gitu kan, yang seharusnya hari ini dikirim barang PMB tersebut tapi karena tidak bisa dikirim karena memang terjadi bencana alam ya tidak ada masalah. Tadi dicontohkan COVID itu juga pernah terjadi tapi kan di beberapa tahun kemudian ada banyak peraturan, ada banyak relaksasi dan lain sebagainya itu menyebabkan kemudian force majeure sudah tidak bisa dipakai lagi. Okay, I think this is your last presentation, right?
Yes, that was it. Well, I can talk
Okay.
about that for probably 60 hours because it's an entire
I
topic,
know.
honestly,
Yeah,
but I
I
just wanted
remember.
to highlight a few
Yes,
special
of course,
things.
of course. Yeah, this is sufficient for now, but hopefully maybe next time we will think about to have you for more than one meeting so we can collaborate each other and we will adopt some of the materials to our learning outcomes.
Mhm.
Um, I will open questions and answers, but maybe I will also ask my students if you want to address the questions in Bahasa, please feel free to do that. So I will try to help you to translate it in English. And also, please mention your name and your student's number just to make sure that I can recognize in which class of you and also the semester. So please, okay, we have Muhammad Raihan Febrian. And also, I only open for three students only because we are almost late. And then Salsa and also Faithful. So the first, Muhammad Raihan. Silahkan kalau mau bertanya.
Oke, mungkin pakai bahasa Indonesia nggak apa-apa ya, Bapak?
Boleh, boleh, boleh. Silahkan.
Oke, jadi kan tadi ada force majeure ya, Pak.
Ya.
Dan itu di apa? Dipakai pas saat bencana. Dan sekarang juga force majeure ini sudah tidak berlaku kan? Apakah force majeure ini akan berlaku ke depannya jika ada bencana lagi seperti COVID-19 ataukah tidak atau ada lainnya begitu, Bapak? Mungkin simpel saja seperti itu, Bapak. Terima kasih.
Okay. His question is more about, is there any limitations on the conditions of force majeure? Is there any specific limitations, scope of force majeure? Because we know that previously we have virus COVID-19 and this is out then from our expectation. So how do we should get to know that some condition is a force majeure? So that's the first question. I think we will gather all the questions first, right?
Okay, all
Okay,
right.
just to make sure. Okay, the second question, silahkan Salsa.
Oke, baik Bapak. Terima kasih atas kesempatannya. Saya Salsa
Ya,
Aulia dengan NIM 2441061 kelas J.
oke.
Pertanyaan saya
Mhm.
mengenai CISG, jika barang terlambat karena bea cukai, apakah penjual otomatis dianggap melanggar CISG dan bagaimana CISG mengatur soal resiko passing of risk ketika barang rusak dalam perjalanan?
Okay.
Itu Bapak.
So she basically has one question on how about if the delay of the delivery of the goods is because of the government policy, for example, like because of the custom duties or to the change of the government policies or requirements. Is that also part of fundamental breach or force majeure? Maybe, yeah, but I don't know. But we need your argument. Thank you, Salsa. Tadi Raihan kelas apa ya?
Mohon maaf Bapak, kelas K, Bapak.
Kelas A ya. Oke.
Kelas K,
Faisal?
Bapak.
Oke, 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 oke.
Ya, terima kasih Bapak.
Faisal, silahkan.
Thank you so much for the time you've given. My question would be, how does silence from the buyer affect contract information? Does CISG recognize implied importance? And my other question is that if Indonesia is a part of the CISG, would it affect like almost everything in Indonesia? That's all, sir. Thank you.
Okay.
All right.
Can you
So,
recognize? Okay.
so can I start responding, one by one?
Yes, 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 of course.
Let's start with the limitation of force majeure. Well, the actual limitation derived from the convention is very simple. The moment the impediment that counts as a force majeure stops and terminates, then the breaching party must resume performance. Other than that, there's no limitation in the convention. So when you refer to the pandemic, it actually, in my example regarding the 2020 March breach of the German seller, that's probably a force majeure. And we don't know yet because the proceeding is still ongoing, but I would be very surprised if the German court could come up with a different argumentation. So this is a force majeure. But the moment, these government restrictions were lifted, I think it happened in May or early June in 2020, then the seller must resume the normal performance of the contract. And it doesn't mean that he can just escape the contractual liability immediately for good. So it doesn't mean that the contract ends and therefore there's no obligation for the parties toward each other. In May or June, when the government lifts these restrictions, he has to perform the contract. That limitation is that the only thing that exists in the CISG. About the delay of delivery of goods due to a government policy, well, it depends, because this is connected to foreseeability. Everything depends on foreseeability in this regard. So is it kind of a routine procedure from this government? Let's say import quarantine restrictions. Do they routinely order quarantine restrictions for these types of goods? If this is the case, then this is a breach. And probably it's a fundamental breach because the seller should have counted with that because it's part of the normal procedure, or at least there's a very high chance that there will be quarantine restrictions or a prolonged customs procedure and stuff like that. So this is the reason basically you really have to get into the knowledge content of the breaching party based on the information objectively available. So is it a commonly known fact for professional businesses, or is it something that the other party should have informed the breaching party upon the formation of the contract? If this delay is not common, it only happens, lately, and maybe the seller is not aware of that, but the buyer knows about that exactly, then the buyer should have informed the seller upfront in the making of the contract that this is an increased risk. And if he failed to do that, then the seller can easily claim that, I'm sorry, I'm not going to be liable. That's a force majeure. I couldn't get this information from objectively available sources. I kind of expected it from you, but you didn't disclose. Okay? And finally, silence, whether it's an implied consent, as what you said, if I remember correctly, where silence only has a relevance in the formation stage. The CISG specifically says that silence never constitutes an acceptance unless silence comes along with the performance of an act. And the performance of that act clearly indicates that basically I'm accepting your offer. So the seller sends me an offer indicating that paying the price will happen with letter of credit. And instead of getting back formally to the seller that I accept the offer, I ask my bank to release that letter of credit and send it to the seller. So the seller receives the seller of credit, and it's going to clearly show him that even if I didn't say anything, I started my obligations under the contract. So this is an implied consent. And the last question was, if Indonesia decides to join the CISG, would it change everything there? No, definitely not. Because the CISG has a very limited scope, only sales contracts, so not contract law in general, and not other types of contracts, only sales. And even from the sales contracts, only international sales. So many countries of the 97 signatory countries, they keep their sales law intact, domestic sales law, and that applies for domestic sales transactions. But the moment they are dealing with an international sales contract, that's the CISG. So this is not going to change everything. It's only going to change your current legal framework for international sales contracts. I hope these were the answers to your questions.
Thank you. Thank you very much. I think that's all. And I think you already respond and answers all the questions. And I do hope that the students who raise questions understand and also recognize your response. And again, thank you very much, Professor, for attending this conference, not this conference, this guest lecture program, as well as providing us a lot of knowledge and information on UNCISG. And I'm thinking about to have more meetings maybe in the next semester for the private international law class, or maybe for the international trade law, or maybe we also have international business contracts course. I need to think about the lecturer that can collaborate in future, because we have few students on that classes. So again, thank you very much. Ya, thank you. And terima kasih semua mahasiswa yang sudah hadir. Saya kira tadi sudah sangat baik apa yang disampaikan oleh Profesor Tamas. Dan mungkin karena waktu juga sudah menjelang malam, kita batasi sampai pukul 9. And thank you very much again for Professor Tamas. And we will see each other again in Zoom, of course, hopefully. And greetings to everybody there. Okay, thank you, and good evening, everybody. Ya, bye-bye. Ya, bye-bye. Ya, terima kasih semuanya.
Thank you, sir.
Oke.
Thank
Thank you,
you.
sir. Assalamualaikum
Ya.
warahmatullahi wabarakatuh. Thank
Thank
you.
you, sir.
Ya. Waalaikumsalam warahmatullahi wabarakatuh. Izin saya matikan Zoom-nya.